YouTube वरही.
Wait, you are using the computer. मी दिसायला नको आपला आवाज पण नको लागा.
Hello, sir. Am I audible to you?
Yes. Am I audible? Everything okay?
Yeah, right, sir. Hello, everyone. Myself, Rituraj, founder and publisher of Bernice Law Journal. And today we have very special guest, Mr. Chander Lall, sir. He's senior advocate and founder of Lall and Sethi law firm. So we are organizing this workshop in collaboration with YCM Law College, Pune, Yaswantrao Chauhan Law College, Pune. So before starting this workshop, sir, please tell us something about yourself, about your background.
Are you starting now? Because it's not 11 as yet.
Yes, sir.
Not 11 as yet. Can you hear me?
Hello. Yes.
Can you hear me?
Yeah, sir. Please say.
No, it's not 11 as yet. So I was saying, are you going to start now or do you want to wait a little?
We can, sir. Our students are joined on YouTube.
Okay. Okay, so am I audible to everybody, right? And
Everybody is requested to mute their audio except speaker, sir.
give me 1 second.
Yes, sir. Please.
So just as a housekeeping, I would suggest I'm going to ask some questions. I think everybody can put in their questions on the chat. I'll be looking at the chat and seeing what the answers are. So that will add some interactiveness to the
Yeah,
talk.
in last 15-20 minutes, sir, we will keep a question answer session.
No, if you have a question, you can type it as a message also.
Okay, sir.
And I'll be asking some questions, so I'll be expecting answers on that. Yeah, then it will become a bit more interactive.
Yeah.
Okay, so a little bit about, I think participants are just coming. I think let's wait till 11 o'clock, another couple of minutes. So we start. Yeah, sorry, I think I got muted. I was saying let's wait for another 2 minutes. The participants are just coming in, so. Is that okay, Rituraj? Can you hear me? Rituraj, you there?
Yeah, sure, sir. We can wait for 2 minutes.
Yeah.
Let the participants come.
Good morning, sir. It will be better, yeah, if we wait for 2 to 3 minutes since the participants are joining. Yeah.
Yeah, that's what I'm doing.
Yeah. Thank you, sir.
We can start, sir.
Yeah. Okay, welcome everybody. Happy to be here. Always happy to share whatever little knowledge I have on the subject, which is very close to my heart. A little bit about myself. I've been in the IP field for the longest time. That's what I started my law practice in. My father was a well-known IP lawyer, partner at Remfree. Then he started his own law firm, Lall. I am the founder of the firm of Lall and Sethi. That was till 3 years ago, and April 2017 is when I got designated as a senior advocate. And since then, I'm doing a wider variety of cases and not just intellectual property law. But last was a boutique IP law firm, so a fair bit of experience on intellectual property law. And I'm told that large segment of viewers are going to be first-year law students who do not have exposure to intellectual property law. So I was asked to make it reasonably basic. So I'll make an attempt to do so. I'm going to share my screen and show you some slides. Can you allow me to share screen, please? Host, whoever's the host, can you allow me to share the screen, please? Yeah, thank you. Can you all see my screen?
Yes, sir.
Okay, I don't know, it stopped. Okay, so that's who I am, currently designated as a senior advocate. I'm going to today talk about intellectual property rights. So basically 4 types of IP: trademarks, patents, design, and copyright. And if you understand this slide, then you understand IP completely. That's how simple it can really be. And I often get asked, can I patent my trademark? Can I copyright my design? It all gets reasonably jumbled up. And I don't think, Radhika, can you please mute your mic, please? Radhika, can you mute your mic? Thank you. So I get asked time and again that what is the difference between the 4 types of IP? These are the 4 essential types of IP, which we call core IP. Then there is, of course, trade also forms part of IP. Bhise, please mute your mic. Okay, I've been muted as well. You'll have to unmute me. I don't know why Radhika is not muting it, but anyway. Can you hear me?
Yes, sir, you are audible.
Okay, thank you. So what is a trademark? It's reasonably simple. As I said, it's a source identifier. To make it simple, for example, imagine if you didn't have a name. If you were just a human being, male, female, how would you introduce yourself when you shook hands? Of course, nowadays shaking hands is not permissible. So when you did namaste to somebody, how would you introduce yourself? You would, and how would people remember you? it would be very difficult for me to try and remember who I met if he or she did not have a name. So that's becomes your source identifier. Your ease with which you are identified by other people is why you give yourself a name. So I'm able to, in the first slide itself, introduce myself as Chander Lall, Senior Advocate, becomes my designation. But Chander Lall is essentially my trademark. Otherwise, it would be very difficult if this seminar was to be organized to say there is an IP lawyer who is this much in age, who's now a senior advocate, who was the founding partner of a law firm. So you can imagine you could go into a whole discussion to describe me if I wasn't being able to describe myself with one name. Trademarks are exactly the same. You can imagine if a black liquid in a bottle had to identify itself as to what it was and distinguish itself from others, and it could not use Coca-Cola or Pepsi, it would be very difficult to identify a product if you just got a can, which was a blank can, which had Pepsi in one and Coke in one, and you wouldn't be able to identify. So anything which connects the manufacturer to the customer is a trademark. Just take that to be the case. So when you're looking and advising clients or understanding what trademarks are, it has no limitations. And when we discuss trademarks in detail, it has no limitations as a source identifier. It can have all kinds of manifestations. It can appeal to any of our senses to be a source. So long as it's a source identifier, it can be a trademark. A patent is really a technology protector. Something which is new and novel technology is what patent protects. So anything relating to technology, you can almost be rest assured that it's a patent. Now, designs are something which are applied to a product and protect shapes and shape alone. So now the distinguishing feature between a patent and a design is that the patent is the underlying technology and not just the outer look. A design is merely intended to appeal to only one of your senses, which is your eye. So anything that appeals to the eye is usually a design or protectable as a design, and we'll discuss that in greater detail. And any form of creativity is protected by copyright law. Whether it's music, writing a book, sketching a picture, taking a photograph, are all aspects of creativity and therefore protected by copyrights. You can obviously see that there is also an overlap between the four types of IP. Now take, for example, if I take I'm just using my cellular phone, it could become, because it has, you can't see it behind this, but there is a eat an apple there, which identifies itself to be an Apple phone. It would also could be a particular peculiar shape, which could be a source identifier. It obviously has all the technology of patents. It has hundreds and thousands of patents in there. The design, the outer shape of the product could be a design because it is appealing to the eye. And it would have copyright material inside this for whatever is written, and also drawings of this particular aspect. So each individual item, including, for example, a pen, could have all the four intellectual properties embodied in it. So don't think it's only one. Now the pen and the manner in which the nib comes out could be the technology part. The fact that it's a Parker pen or any branded pen identifies the source, it has a trademark. It could have a peculiar shape to it, which gives it a design protection because that shape is appealing to the eye. And then copyright could be in the industrial drawings which have resulted in manufacture of this pen. So all four intellectual properties subsist in a simple item such as a pen. Now, when we look at the governing legislations, the second, third, and fourth intellectual property are strictly statutory in nature. Trademark law, on the other hand, has an element of common law or tort involved in it. So trademarks can exist and existed even prior to the Trademarks Act being incorporated. Of course, this is the 99 Act, but the earlier legislation as well. So trademarks exist and existed under common law as well. We'll talk more about that. But it also exists under the Trademarks Act 1999. But Section 27 of the Trademarks Act categorically states that nothing will restrict an action, what is called an action for passing off. Now, passing off is a remedy under trademark law, broadly termed as a remedy under trademark law, which is outside of the Trademark Act and falls in the domain of tort or common law. So it is possible not to incorporate your elements of registering a trademark and yet having all elements of protection of a trademark outside of the Trademarks Act under common law. So whether it is registered or not, and we'll talk more about that a little later when I talk about trademarks. Trademarks are protectable. So you'll get asked many times, of course, you're not practitioners or whoever are the practitioners, you'll get asked many times, but my trademark is not registered, can I still protect it? The answer is yes. But when you say my patent is not protected, my technology that I have incorporated into a particular product, say this pen, is not protected. In that case, if you have not registered a patent in each individual country where you want to protect your patent, you will have no patent right. So it's strictly contract, it's strictly statutory in nature. The same is true for designs. You need to register your design to have statutory protection of a design and a patent to claim protection. Now, copyrights, though strictly under the statute, are governed only by the copyright law and not by common law, is a very unique situation. Whereas members of, and we'll again discuss that further, as members of the Universal Convention and the Copyright Convention, Universal Copyright Convention, you can claim protection without registration cross countries. So we'll discuss that a little bit more. But what I wanted to show by this slide was trademarks governed by the Trademarks Act and common law, patents strictly by the Patents Act, designs strictly by the Designs Act, copyright strictly by the Copyright Act. None of these last three legislations you can apply any common law principles. You have to look for all answers within the statute. Whereas for trademarks, you can look outside of the statute. Now, what is the life of intellectual property? Obviously, being intangible property, these properties can or need not have a life. Now, trademarks have a life and yet have the capability of being eternal. Coca-Cola as a trademark has existed for over 100 years. Patents have a very limited term, which is 20 years. This is defined by the statute and by various conventions. So world over, it is virtually 20 years. Designs are protectable for 10 years and an extendable period of 5 years. And copyrights, in most cases where the author, works of authorship, it's life of author. So it's whoever has created the work, his entire life, plus 60 years post his death. And that 60 years post his death, the year that he dies, is excluded. So if you die in January, then you get an additional year. But if you die in December, then you lose that 1 year. So that year in which the author dies, and then 60 years after the life of author is the life of copyrights in most cases. And virtually these are global conventions. How can trademarks be eternal? It's again, going back to the first slide, so long as it continues to be a source identifier, it will continue to exist. Now, let me give you an example. You'll go to courtrooms and see a slip put up in front. Can you give me a Xerox copy? Or please provide, counsels are requested to provide Xerox copies of judgments. Xerox was a trademark or is a trademark, but it has virtually gone into public domain because it has been permitted to be used as a descriptor of photocopying machines. There are several such examples where trademarks have been lost on account of them being very famous. Refrigerator, whether you believe it or not, was a trademark. Yo-yo, that toy that we play with, used to be a trademark. Dry ice used to be a trademark. And there can be several such examples that you can think of where trademarks have gone into public domain owing to the fact that there was a specific article that they got associated with, such as a photocopying machine in the case of Xerox. And that then became common parlance used for photocopying machines and not as a source identifier. And hence what happened to a trademark was it got diluted in the sense of no longer being a source identifier, that photocopying machines manufactured by Xerox Corporation were the only machines that could be called Xerox. But in fact, Canon machines also started being referred to as Xerox machines, and therefore it lost that identity. Coca-Cola went through a similar, I guess students your age, you wouldn't remember, but we used to go when Coca-Cola times pre-1977. And when we wanted a cola drink, there was no Pepsi that time. And we used to say Coke de do, which meant give me a cola drink. So this kind of misuse can destroy a trademark because it no longer remains a source identifier. Patents are granted for a period of 20 years. This is from date of filing. There are certain conventions, so you can claim priorities. The starting date of patents is very critical because it is a technology-based protection, and therefore, if anybody comes out with the technology after you have filed for a patent, you will get priority over that technology. Similarly for designs. Now, and copyright I've already discussed. Now, territoriality. Is it possible to protect trademarks globally? The answer is yes. Trademarks can be global in nature, even though the Trademarks Act 1999 applies only to trademarks registered or protected in India. But I will talk more about how they can be global. Patents are strictly territorial. You need to apply for patents and obtain registrations in every territory that you need to protect that patent. Designs are also strictly territorial. Both of them have a global impact because if what's important for patents and design is newness and novelty, we'll discuss that a little bit later. But every invention or design which appeals to the eye has to be new and or novel on the date on which you apply for registration of that patent or design. And newness and novelty must be global in nature. That is, that nothing of that technology should be disclosed to any member of the public prior to the date of your application for registration of design or patents. Now, copyrights. So novelty is the key to patents and design, new and novel. So something unusual which didn't exist earlier must be the subject matter of patent. The shape must not have existed earlier. It must be new and novel for it to be a design. Now, copyrights is an entirely different animal. Here, the term, and I should have had another slide, but originality is the issue. So a copyright should be original. It need not be new or novel. So it's very peculiar. Originality means originating from the author and not copied. So long as it originates from you, so if you are able to convince a court of law that you painted the Mona Lisa without having or ever seen the Mona Lisa, you will get copyright protection over that. You may write a book which is in all terms identical to another book of a previous author. So long as you have not read that author's book, of course, this is a hypothetical. If you have not had access to that author's book and you have not copied that author's words, it is possible that you just happen to write exactly the same thing as a previous author or painted something which is exactly the same as the previous artist, and you will get copyright protection because it originated from you. On the flip side, if there is access and you've copied and you've tried to make many changes, the copyright protection may be lost. So it does not originate from you then, and therefore it is lost. Now, copyright is global in nature because most countries are members of the Berne Convention and the Universal Copyright Convention. Now, it's very unique. People say I wrote that book. People say I painted this piece of art, but I didn't copyright it. Can I now protect it? And that's where the confusion arises. Same thing with trademarks. I have a trademark. I've been selling products under that trademark, but I haven't registered it. Well, copyright registration is not mandatory. It is not even advisory. In fact, it gives you no additional benefit other than putting a date when you apply for registration of copyright. But copyrights subsist in all those countries where all those countries who are members of the Berne Convention and the Universal Copyright Convention. Now, what do these conventions, and this is very important for the new generation to understand copyrights, and I get asked this question many a times. Sir, can I download material from the internet and use it? Because it is open and it is available in the public domain. Is it therefore possible for me to download that material because somebody has actually put it on the internet? This piece of music, can I download it because the person who wrote the music or the person who's recording it has put it in a public forum? I have chosen to put something on LinkedIn or Facebook, say a piece of poetry or my art, or shared some thoughts. Can I download those because they are public and they are in the public domain? The answer is no, so long as the author of the work is a member of any of the countries who are members of the Berne Convention or the UCC. They are protected by copyrights in all Berne Convention and UCC countries. So if there is an English film made in Hollywood, it is given the same level of protection as a Hindi film made in Mumbai. Exactly the same level of protection, which with no further registration requirements or any other form of protection, it is straight away protected as a copyright, and it will be given a copyright, a full measure of copyright protection as an Indian film. The reverse will also be true, which is that the Indian film will be protected in the full measure as a Hollywood film would be in the United States of America. So that is the global nature of all copyrighted works. So what is critical to the next gen is music, which is uploaded on the internet, written text, which is uploaded on the internet, films, or even small films, which are not published films in the sense that you shoot a film and put it for a 2-minute film or a 3-minute film and share it on Instagram or Facebook or any other social media platform. The copyright vests with the person who has shot that film. And that copyright protection is equivalent to a copyright protection of a production house in Hollywood or a producer in Bollywood or any other form of any other good that may exist anywhere in the world. So it is very global in nature with very little requirements which are for registration or other forms of protection. How are trademarks global? Trademarks can be global by knowledge of the mark in different countries. And I'm going to share a very interesting example. We argued the Whirlpool case. I was very young that time, and my job was to collect evidence of Whirlpool being, whether Whirlpool was known in India. And an Indian company had applied for and obtained registration of Whirlpool in India. And Whirlpool Corporation of the USA did not have a registration in India, and it had in fact allowed its registration in India to be abandoned. What we had to show was that the Indian public had knowledge of Whirlpool USA and the white goods and washing machines, etc., that were manufactured by Whirlpool Corporation. And so long as that knowledge existed in India, it was protectable under trademark law as under a tort of passing off. And in two things broadly, I'm just going to discuss that despite a registration of the Indian company in India, passing off succeeded and overrides the registration because we were able to show reputation and goodwill of the trademark Whirlpool in India. prior to registration of the mark in India by the Indian company. Therefore, Whirlpool USA had, as the court held, better rights than the registrant of Whirlpool in India. So that's how global, and subsequently in the 1999 legislation, these aspects were brought into the Trademarks Act, and you read those in section 11 and section 29. The concept of well-known trademarks, that if the trademark is well-known, then it has a different treatment altogether. For infringement, it has a different treatment altogether for registrability. And the Act now also protects what are called famous marks, well-known trademarks, which you will find references of under the Trademarks Act, which did not exist prior to the 1999 legislation in the 1958 Act. So they can also be global in nature, provided there is a spillover of reputation and goodwill. So let us look at trademarks first. Again, reiterating, it is an invisible link between the product and its source, and that link can be known or unknown. You need not know who manufactures Coca-Cola, for example. It could be the Coca-Cola company, or it could be owned by anyone. As you know, the Jaguar motor car company is today owned by Tata. So you need not know that that link is Tata, or that link was earlier the Jaguar Motor Company, which was owned by a British company, which is a British company. So it is anything which is a link between the product and its source is a trademark. On the right hand side, you can see a factory being made. So from the factory, what comes out is a Lacoste t-shirt, and you identify a Lacoste t-shirt just by the crocodile or the word Lacoste, and you know that this is a product of a French company. It is a high quality product, it is a high priced product, and something which is desirable. And in the world of t-shirts, it is a very renowned kind of a product. So what can trademarks be? It can be a word, it can be a slogan. You know of the Nike slogan, just do it. It could be a device, the famous Rolls-Royce device which you're seeing here. It could be the Nike swoosh device which you see on shoes. So it's not saying anything, but it is still representing that the shoe which has that swoosh device, or the vehicle or the car which on its bonnet has the flying lady, as they call it, the flying lady statuette, is a Rolls-Royce car. In the case of product shape, you can see that the Rolls-Royce car has a very peculiar front grille. And that front grille, the way it's made, the visual appeal of the front grille is an identifier that this is a Rolls-Royce car. And even if I was to remove the flying lady statuette on the top here, you will be able to identify this car as a Rolls-Royce car. So hence the front grille becomes a trademark. We actually sent notices to a restaurant which had put up a front grille outside its restaurant to identify itself as a premium restaurant, to say that it was a Rolls-Royce type of restaurant. And they had to remove that because it was a famous mark. Characters. So Lacoste was a famous tennis player, and he was known as the crocodile because he was a very aggressive tennis player. And therefore he decided to choose the crocodile as the shape, as his logo. And today has become so famous that you just see the crocodile on a t-shirt, and you're able to identify that as a Lacoste t-shirt. Same with, you can see the Tommy Hilfiger logo, the red and white logo which appears on a t-shirt, you're able to identify. It could be the name of a designer. All the designer names that you see today are actually full names of a designer, Salvatore Ferragamo, and all those names are full names of designers who have now become famous. Many Indian designers also you recognize as trademarks, as goods emanating from those persons. They could be numerals, as 555 for cigarettes. I don't think they're still available. Very interestingly, it can also be sound. So if you've heard the Yahoo sound or the Yahoo Yodel, or other forms of sound, including the Harley Davidson motorcycle sound, were subject matters of trademark and can be subject matter of trademarks, because when you hear a Harley Davidson motorbike starting, you know it's a Harley, and that sound was put into the bike not by virtue of the fact that that was the sound of the engine, but it was particularly put in by Harley Davidson to identify its product. And then, of course, it could be a signature, as in the case of Johnny Walker. The person who blended that whiskey actually put his signature on it, and it could be a signature. So it could have any physical representation, which could be a trademark, a simple word, a slogan, a device, a name, a numeral, a label. So you've got to look for really any aspect which identifies source. If you hear Amitabh Bachchan's voice today, for example, you'll recognize it as Amitabh Bachchan's voice. And if you were to use that voice, or somebody else was to imitate his voice to promote a product, that could be considered a trademark violation, because his voice becomes his trademark and people would think that it's Amitabh Bachchan who's endorsing that product, and he would be able to stop that. So the purpose of a trademark really is to help a customer identify the source of the goods, to distinguish the goods of one manufacturer from the other. So when you put a Coke on a can, it distinguishes it from the Pepsi which says on the can, and both may taste similar, and you and I may not be able to distinguish the taste, but by name we are able to identify that one is Coke and one is Pepsi, and we make that choice. So it distinguishes my goods from the goods of another party. It tells the customer that this can which has Coke written on it comes from source A, and the can which has Pepsi written on it comes from source B. So it helps the customer identify the source of the goods. It distinguishes the goods manufactured by a particular manufacturer from the competition, and it serves as a very powerful marketing tool. Why is it a powerful marketing tool? I gave you the example of having a bottle full of a black liquid which had no name on it, and I asked you to drink it. You would be very hesitant. If Coke was to now, or the company who makes that was to pitch it to you and say, look, this is not harmful, it looks black, it looks ugly, but it is actually sweet in taste, it won't harm you, it's made in very hygienic conditions, and it quenches the thirst. It would have to be a whole conversation. Instead of that conversation, it just says Coke. That same conversation then gets totally highlighted into the word Coke. It gives you that message in your subconscious that when I see Coke on the product, it is actually a product of good quality. It is a product which comes from a very good source. It is a particular taste that I'm used to, and I will immediately put it to my mouth and drink it. But the moment I allow the Coke brand, and tomorrow there are several counterfeits of Cokes, and when I drank the Coke last time, it was a counterfeit product. In the case of, say, Kinley or the water bottles that we get today, there's a lot of counterfeiting. So why are people wanting to stop those counterfeits? Because I pick up a bottle, I go to a railway station, I walk out on the streets and I'm thirsty, and I buy a Kinley or a Bisleri bottle. I expect a certain quality. If that quality is lost, and if that quality is lost because there are third parties who are manufacturing it without the necessary quality control that is applicable, then that quality control reflects onto the brand, and I'm able to then not able to take that decision that Bisleri is a good product or Kinley is a good product, because there are lots of counterfeits of that product, and therefore I could still get sick. And the brand starts to get diluted, and that customer confidence starts to get diluted, and the trademark rights are lost. So as I said, use of a trademark is the life of the mark, and registration provides only an additional remedy of infringement. So what is the meaning of this? The moment you adopt a particular source identifier as your trademark and start promoting it as such, every day that customers associate that particular source identifier with you, you are strengthening your brand value. So the more people who recognize your trademark as a trademark, the stronger your trademark. So if 100 people know it today, it is strong. As 200 get to know, it is stronger. As 2000 get to know, it is even stronger. If it is known only in Delhi, it is a Delhi specific mark. If it is known all India, it becomes an all India mark. If it is known globally, then it becomes a global mark. So the territoriality of a mark starts to expand with the people who acquire knowledge of that brand as and when you start using that brand extensively. Registration helps, but it is not the all and end all of trademark protection. So you can have a trademark which is unregistered and yet protected better than a registered trademark. So what are the advantages, you would ask, of registration? One of the biggest advantages of registration is that you just need to produce the certificate of registration and you will get protection from a court of law, because you get what is called a statutory remedy and a statutory relief under the Trademarks Act. There are 45 classifications. So trademarks also exist very closely linked to goods. So trademarks don't exist in a vacuum. Trademarks only exist very specifically with the goods with which they are associated, because it is a link between the manufacturer and the consumer. So it is linked to a particular type of products. The type of products are divided into 45 classes. This is just for purposes of administrative purposes. So for example, automobiles will fall in class 12. In class 25, I think, are sporting goods. Soft beverages will fall in a different class. I now forget all the classifications. Pharmaceuticals fall in class 5. Pharmaceutical and medicinal preparations fall in class 5. Chemical goods fall in class 1. I think sporting goods fall in class 24. Apparel in 25. Alcoholic beverages and all in 34. I think it's like cigarettes are in 34. So there are different classes in which broad segments of goods are divided, broadly to see that there are related and correlated goods, and therefore the protection is narrowed down to a particular type of goods, and you register your trademark for a particular specific type of goods. So if it's 555, then you register it for cigarettes. If it's Maruti, it could be for automobiles, or now also for oils. So it may, unless it's famous and it spills over to different goods, it's possible. For example, if you were to see Coca-Cola on your t-shirts, you would still associate it with the Coca-Cola company. If you were to see Coca-Cola on a cellular phone, you would associate it with the Coca-Cola company. So it has a tendency to also spill over across goods in the case of well-known and famous trademarks. So although it's restricted, but within common law, it can expand beyond goods. But for registration purposes, you are supposed to apply for goods for which you want protection. That is, the goods for which you use the product, the mark. For the products that you use the mark, you apply for registration for those goods and a wider expanse of goods for which you want to have protection. It's important that your registration, that you use the mark in relation to those goods. So if you are registered, say Coca-Cola for soft drinks and soft beverages, and it is not used for a period of 5 years, it is liable to be removed from the register, because trademarks must be alive and must be consistently used with goods. Let's look at designs. Designs, as I said, are pure visual appeal. So it's features of shape, configuration, pattern, ornament, composition of lines or colors applied to any article, whether in 2-dimension or 3-dimension. So what is a design? It's a feature of shape of a particular article, let's say a pen. It could be a configuration on this. So it could be configuration of this article on the, or a pattern or an ornamentation on any particular end product. It could be composition of lines or colors applied to an article, whether in 2-dimension or 3-dimension. So it could be a design on a sofa, say on tapestry. It could be the stitch of a particular fashion article. It could be a teacup, a teapot, which has an ornamental feature to it, would be protected as a. Now, for example, I have this pen holder here, which looks like a shoe. So this would be a design which is purely ornamental, although it has a functional feature to it of holding pens, but it's in the shape of a shoe, and therefore it's appealing to the eye, and somebody would want to display this on his table and make a purchase decision based on his eye appeal. So this would be a design registration. It would be registered for 15 years and this person would have the exclusive right to use this shape for a pen holder. Designs must not be utilitarian. The moment I claim, of course, every design has to have a utility also, but it should not be primarily utilitarian. In this, the shape of the article of a shoe has no utility other than holding a pen, but then the pen holder could have several different shapes. And therefore, the shape of the shoe, and specifically this portion of the shoe, has no utility whatsoever. It's purely to appeal to the eye, and therefore for people to make a purchase decision as an eye appeal feature, and it would be a design. If I use this shape on my t-shirt as a logo, this could also, the very same shape could become a trademark. So like the crocodile, I could have, when I start making pen holders, now I realize from pen holders, I have a interesting idea of putting this shape in the form of a tapestry and put it on a t-shirt. That becomes a source identifier and therefore becomes a trademark. Now there could be some technology involved in this also, which is that when the pen, I put it in, it sort of, I don't know, it sort of comes through, or the pen looks smaller or holds more pens because it goes into a particular area. I can't fathom what kind of technology I would, but if there was a technological development in this, which is perhaps, let us say, something as innocuous as, because of the laces in this, I'm able to put the pen also within the laces, which is then easier to pull out. So there is a utilitarian aspect to the lace as well. That could form the subject matter of a patent. And if these are made with drawings, and I would draw these out as industrial drawings, or I had sketched this out first, an artist had sketched this out, that would be subject matter of copyright. So again, just to remind you what the other forms of intellectual properties are. So designs, very clearly, it relates solely to the appearance of the article, that is appeal to the eye. So it must only appeal to one sense, which is the eye appeal, the visual appeal. It should be ornamental in nature, and purely ornamental in nature, and have no utilitarian aspect to it. It does not include mode or principle of construction or mere mechanical device. This mode or principle of construction or mechanical devices will be covered by patents, not by trademarks. Registration is mandatory. Now, this is critical prior to publication. I talked about it. Registration of designs will have to be done before you make this shoe publicly available. So you cannot, if you come up with this design as an artist who has developed a new and novel design, you can't go into a seminar room and discuss this design with members of the public. You certainly can't launch this product in the market and then apply for design registration. So what you have to do is you have to anticipate that this design shape is new and novel. It is an eye appeal design shape, and therefore I want to protect it as a design. I must apply for registration of this design in every country that I want to protect it. And therefore, before publication anywhere in the world, I must apply for the design registration in all parts of the world individually where the design is required to be protected. Then after applying, and there are some conventions, so you get time within which you can apply. 6 months, you can apply within 6 months. You get the first date of filing anywhere in the first country. So if it is January 1, you can file by the middle of the year and claim January 1 as your date of priority. So that between January 1 and if you published it thereafter, between January and middle of the year, you are able to claim priority of January 1, and it's not lost because of prior publication. So you protect that and then apply for it. And then when you, registration will come later, of course, but then you can publish the design after applying for its registration in all the countries. That is also true for patents. So novelty, not originality, is the key. Protection is granted to new and novel designs. Novelty is the fundamental reason for the protection granted. eye is the ultimate judge. Thus, novelty should be substantial. So your eye must be able to distinguish between known designs, which are common use designs in the market, and what is new and novel for a design protection. What are unregisterable designs? Designs that are not new or original. So they have to be new and original, originating from the person who applies. Designs disclosed to public anywhere by publication in tangible form or by use in any other way. This is what I was just narrating earlier. Designs cannot be disclosed to the public without applying for their registration. So you must disclose the design to public, must not disclose the design to the public before applying for its registration. So it's a lot of designers ask us this question, that I came out with this design and somebody's copied it, and they have not filed for a design registration before actually putting that garment out there in the market. They've lost that design registration by virtue of that publication. Designs which are not significantly distinguishable from earlier known designs are not protectable. Scandalous or obscene designs are not protectable. Coming to copyright. Now, copyright can be, what are the subject matters of copyright? These are works of creativity. So films are something that all of us are familiar with, are subject matter of copyright. Now, films are what we call a multimedia format because they embody several copyrights, but the end product, the film itself, is subject matter of copyright. Musical works, interestingly, till 2005, musical works in India meant written notational musical works. Now, musical works are different from sound recordings which we hear. Music is as by a composer, as composed by a composer. And as I said, till 2005, it was required for musical works to be protected to be in written notational form and not in the form of hearable, which I can hear audible form on a at those time discs or whatever the formats were available then. Then there are, as opposed to musical works or as compared to musical works, are sound recordings. Now you see musical works stand in the middle. Musical works are the basic copyrights which existed before sound recordings came into existence. So even before sound could be captured on a disc, musical works existed by people playing the music live, which is why I had in the previous slide, you see the composer and you see the person playing live. So musical works traditionally existed like this. Then came sound recordings of the work, which is you could capture that music, the person playing live, onto a format which was earlier analog, but today is digital, is captured on a record player earlier and subsequently converted to digital. And so really it's two different things. Somebody who writes the music, composes the music, is different from the person who makes the sound recording. The composer of the musical work is the owner of the musical work. The producer of the sound recording and the film is the owner of the producer, and the owner is the owner of the first owner of the copyright of sound recordings and films. And as you can see, musical works will go into sound recordings because you need the composition, and sound recordings eventually will go into films. So it's sequential. The film producer will need to obtain permissions from the musical work owner and the sound recording owner before he can use those works. Then there are literary works. Now, computer programs are also, of course, literary works, as in the traditional sense, you're writing down something. So whatever notes you may be making of this particular seminar, for example, or it's sitting in front of your desk, are your literary works protected by copyright globally. Books are literary works. Computer programs are the latest form of literary works because computer programs are nothing but computer readable literary works. So they are also works written by man, but which are readable by computers as well. Hence, they are also treated as literary works. Then there are artistic works. Within artistic works, you can see that there are works of photography. There are engineering drawings. There are works of sculptures. There are works of architecture. These are all treated as artistic works, not just paintings, but photographs, industrial drawings, and works of sculpture, and even architectural works. And then dramatic works, every cinema. So earlier dramatic works used to be literary drama and plays played live. Today, dramatic works will also go into films. So you can see the film, which is the top of the bracket. You will use musical works as musical compositions, will use sound recordings. You see Hindi movies with all kinds of music being played and songs being played, being embodied into the film with visuals. The moment it becomes with visuals, it becomes a film. When it's without visuals, it's a sound recording. It will also have a script. The script of a film would be a literary work. Somebody who writes that script so you would have to take permission. And artistic works and dramatic works. So these are the 6 principal kinds of subject matters of copyright. Now, what are copyrights? They're a bundle of rights. So copyright is not one right. Copyright is not as if there's just one copyright. It is a bundle of rights bestowed by the law on the creator, author of an original work. As I said, not new or novel, but on an original work. This is just to keep it simple. It's a bundle of rights. So, for example, a film or software in our case more, a film is a bundle of rights by which you can run only the soundtrack of that film. You can run that film on the internet. You can run that film in a theater. You can put that film on a disc. These are all separate and independent rights. And it's very important to recognize and protect those rights and also respect those rights. So if I give you, when you purchase a software, for example, you are only licensed to use that software for purposes of using it on your personal computer. That same very subject matter of copyright as software, the moment you use and make more copies or put it on your office server or use it for commercial purposes, you require a different license. Your initial license may not cover it. If you see the Zoom license itself, you can get a license which is free, which is then goes off in 45 minutes. Or you can get a license where you can host webinars for 100 people, 500 people, 1,000 people. You can't take a Zoom license for 100 people, crack it and use it for 1,000 people. Crack the code and use it for 1,000 people. That would be copyright infringement because you're cracking the software. So what does this bundle of rights contain? It is an exclusive right to reproduce it in any material form, which is that when you download it, work from the computer, you are actually making a copy of it on your computer. That is reproduction in material form. A depiction of 2D work in a 3D. So I can't take a drawing, an architectural drawing, and make a 3D work out of it. I can't take a 3D work and convert it into a photograph without permission of the person who is photographed, or the building that is built by an architect who has copyright in the building, to convert that into a 2D picture. So these are just the broad protection. The rationale behind copyright protection is creativity and protection and a reward to that creativity. The purpose and all intellectual property, because it is property of the intellect and these are all intangible properties, is to grant a certain reward for creativity, in turn creating an atmosphere conducive for creativity. So it's giving, for example, patents gives you 20 years protection, because if I was to create something new and I didn't get patent protection, I would keep it to myself as a trade secret and not share it with members of the public. In return for my sharing it with members of the public, I'm given protection under the Patents Act. And under the Patents Act, then I am given exclusivity to stop other people from using my patent for a period of 20 years. The same is true for copyrights. For creativity, I create a piece of art. I would normally then not disclose it to people. I would make a film and not disclose it to people with the worry that people will copy it, but for copyright law. So as soon as copyright law comes into existence, I'm able to protect my copyrighted works. The acquisition of copyrights is again very important, and I'm going to spend a little bit more time in copyright because that's what we use every single day. And copyrights don't require registration for protection. So therefore, every work which is falling in the subject matter of copyright, whether it's a film, whether it's music, whether it is this webinar which is being taped by somebody, these are all forming subject matters of copyright without any further protection or any further form of registration. And this, you can only acquire rights and copyrights not by saying, okay, you can use my picture orally, but by assignment or license. And these licenses have to be in writing. So you have to have these licenses in writing. These licenses also require specifically for identification of the work, the period of the license, which is how long you can license for. When, as I said, it's life of author plus 60 years. How much period is that licensing? It could be for 5 years, 10 years, 15 years, or less. I could give you as a one-time use. I could give it to you for life. I could give it to you for life, my life plus 60 years, or the entire term of copyright, or restrict that. Also, the amount of royalties required to be mentioned. The territoriality can be determined. So if I can allow you only to use my film in India, or only in a theater, or use my music in a limited only for purposes of one particular performance in a seminar or in any other format, and no more. So territorial extents and 1 year exercise of right is it's a little complicated, because if I give it to you for something and you don't use that work for 1 year, for which suppose I give you my script of a film for you to make a film, and you don't make a film within 1 year, then that right reverts back to the owner of the script writer, unless the contract provides otherwise. Terms and registration. Copyright, as I said, extends for life of author plus 60 years. There's no statutory requirement for registration. Subsists with the creation of the work. And India is a member of the Universal Copyright Convention and the Berne Convention. And therefore, there is reciprocal protection, not just for Indian works abroad, but for in India. Coming to patents, which is the last, this gives protection to inventions as in now, other than visual appeal, but more technology driven. Inventions must be new, useful, and have industrial application. So they must be one should be able to apply them to industrial products and must have an industrial applicability. They must relate to a product. Improvements can also be patented, and sometimes very small improvements are patented. Of course, they must have that basic requirement of an inventive step to be subject matter of a patent. And it is a right, it is not a positive right, but a negative right, a right to exclude others from making, using, or selling the invention. So you're given an exclusionary right to stop third parties from using your invention or selling products covering your invention. This is old. It's 20 years now. This was under the old act, where it was 7 years for pharmaceutical patents. Obviously, I pulled out some old. So it used to be 14 and 7 years for pharma, but it's now standard 20 years. In the case of patents, it's novelty, not originality, which is the key. So here, novel means if you are to make the Mona Lisa again, there is no novelty, even if it completely originates from you. So you don't need to copy. Even if you by chance hit into an invention which is identical to a registered patent, you will infringe. You may not infringe the copyright, but you will infringe the patent. So it is protection only for new and novel and original works. Novelty, though, is the basis for protection. And discovery of a new property or use of a known substance or in apparatuses. So discoveries are not exactly of a known substance or apparatus, are not an invention. Remedies for infringement, broadly for all forms of intellectual property. Patents don't have a criminal remedy, but for copyrights and trademarks, there are civil and criminal remedies applicable, which you can find in the Trademarks Act as also in the Copyright Act. In fact, Copyright Act invites a minimum penalty of 6 months jail term as well, and a certain amount of, I think it's 50,000 rupees as penalty amount. So there are minimum penalties prescribed for copyright violation. So which means for software piracy, film piracy, music piracy, there are minimum penalties, criminal remedies applicable. So be very careful when you use copyrighted subject matter works. Trademark law also has criminal remedies, which are slightly more difficult. Patents and designs do not have those remedies. So I think I've run out of time, exactly 1 hour. I'm happy to take questions. Anybody has questions?
All those who wants to ask the question, please raise their hands.
No questions? That's a good sign.
Good afternoon, sir.
Yes.
So my name is Akanksha Bharadwaj.
Yes, Akanksha.
So I have a question. So like you said that we have copyright of our work, but the things or documents which are on the internet and we use to copy it for our study materials or something else, and this happens in our day-to-day life. But sir, as there is a copyright, there is also a violation as we download the material or copy it. So how to deal with such cases which happen in day-to-day life?
So I'm just going to show you copyright. I think what you really need to look at, and your answer lies, if you can see section 52 of the Copyright Act. And if your answer does not lie, yeah, go on. Right. So copyright, you can be rest assured, whatever you're downloading from the internet is protected by copyright. I know it sounds very unfair that you're not able to because it's staring you in the face. You can go and locate that material on the internet, but you're not able to download it. But there are certain exceptions for fair dealing. For example, the example you gave was private or personal use, including research. So if there is a following act shall not constitute infringement of copyright for private or personal use, for criticism or review. So you can see that there are exceptions for private or personal use. So to download material and use it for research and private or personal use will not be infringement of copyright. Clearly, you can see for computer programs. So 52 is your complete answer. Please look for what you are doing. If it is covered under 52, you're protected because it is certain acts not to be infringement of copyright. If you're not covered by section 52 of the Copyright Act, in all likelihood, you are infringing. Does that answer your question? Any other question?
Yeah, there is a question from Varnila Mishra. Can one trademark have two different proprietors?
The answer is yes. It is possible if it. So same trademark can have two different proprietors. It happens a lot of times in the case of companies which are family owned. Take the case of Hero, for example. Hero has a trademark. Today, there are 4 different sections of the Hero family who own the Hero trademark. They've divided those into different product categories and own the same trademark by different companies. So it is possible sometimes for the trademarks to be split up and owned by different companies for different product lines or even for the same product, but then with some distinguishing feature between one or the other. Haldiram is another example which has several owners. So yes, it is possible to have multiple owners in cases where families split and then they want both part of the same brand.
but
afternoon,
they
sir.
can be registered as a joint proprietors. Same.
Yes, joint proprietors is possible, and I can show you that. Let me just see. Sorry, wait. Jointly owned trademarks is possible under certain conditions. I'm just going to show you that. Registration is, sorry, this is. I can't remember the section, but yes, jointly owned trademarks, it is possible. As joint proprietors, 24. So if you see section 24 of the Trademarks Act, jointly owned trademarks, it is possible to register 2 or more persons interested in a trademark. There are certain restrictions. Neither of them can claim against each other, and they can be registered as joint proprietors. And joint proprietors is common when it's in a partnership, for example, is a joint proprietary, where 5 individual partners own the trademark jointly and not severally.
So is there any more questions?
Good afternoon, sir.
Yeah, good
Please
afternoon.
go ahead.
Hello.
Yes. Go on, I can hear you.
Am I audible? Yes.
Yes,
Thank you,
yes,
sir.
yes.
So my question is, if I write a poem or anything musical work, I wrote that, and one of my friends asked that, can I use it to impress someone, and I agreed to the same. Because of that, that poem became viral and gone hit. So can I have still my copyright?
Yes, because you are the author. The person who made it viral is not the author. But your problem will be that when you write out the poem and you give it to your friend, there is no evidence that you wrote it and your friend didn't write it. But strictly speaking, under law, you are the author and first owner of the trademark. So if you see Copyright Act Section 2 and see the definition of author, then the first owner is the author. In relation to a literary, you're talking about a literary work, which is your poem. The author of the work is the first owner under Section 14 of the exclusive right in the case of literary. So you can see that the owner in this case, provisions, where copyright subsists, it will be in a literary work, and the author under Section 2 will be the owner, first owner of the copyright work.
Thank you, sir.
You will be the author, but then you must maintain some evidence that you wrote it and gave it to your friend, who then narrated it to somebody, and then it became viral. So the problem is that you would have just written it in your house and given it to your friend, and your friend will deny that you gave it to him and he made it public. So it'll almost be impossible for you to lead evidence to show that you actually gave it to him in the succinct of your house, and therefore he may claim that he wrote it. But if you can show evidence that you actually wrote it and you were the author and you gave it to him just for his personal use, and he doesn't fall within 52, obviously he made it public, he would be a copyright infringer.
Thank you, sir.
Is there any more question?
I have another question if we're still taking questions.
Yeah.
So it's very popular and viral right now in the age of Instagram. So many social media challenges are coming up where artists and other film stars are giving the general public certain social media challenges where they come up with a short video or a performance or something creative using music which they do not have the license for, and they submit it for like a competition which might have a non-commercial prize, like it could be a video call with the artist if they win or something of that sort. So is licensing required in such kind of like, will there be any copyright infringement if people, the public submits their work to such artists?
Absolutely. Now, again, if you see 52, that would not be, where would you fall under? It is not private or personal use, including research. It is not criticism or review. It is not reporting of current events. It is a commercial use. And you can see that there's all non-commercial uses in 52 are exempted. This would clearly be commercial use, even though there is no money changing hands. So it is possible. Of course, the issue is whether it would be worthwhile for the copyright owner to chase down somebody like this. But it has happened many a times that such works have been asked to be pulled down. And if you notice, if you try putting up stuff on LinkedIn and all, or even YouTube will not permit you. They are able to check that this is subject matter of copyright. If you put up music, you make a personal video and put music, which is commercial music, they will allow you to put it up, but not use that video for commercial purposes through YouTube. So to commercialize it, you will need to show licenses to YouTube. Then only will they allow you to commercialize that video, because it contains songs of commercial songs which don't belong to you. So you would have to give them a declaration that all music that is inside that belongs to you, and they will be able to make a comparison with commercial songs and find out that this music, whatever music, suppose of a film you've put in at the background music of your video, they will put it up, but only for private use and not for commercial. You can't commercialize that video. So this would be what the example that you've given is clear commercialization by the actor who may have put it there. And it is possible for music companies who will own rights in that music to come after that event or that actor. And if there is monetization, to also sue for damages. So they do run a risk, but you're right, many people do it because it's very difficult to keep enforcing. And we are still going through that process of development on the internet. But people have started watching the internet and being more careful about it and being more forceful about enforcing their rights, which is going on various social media platforms.
Thank you, sir.
Hello, sir.
Yeah.
Sir, I have a question related to patents.
Yes.
Sir, if a company is successfully able to develop a vaccination for coronavirus, can they claim a patent right over it, keeping in mind the present situation?
The answer is yes. But patents, like all intellectual property rights, are in public interest to sort of develop innovation, to give you incentivize innovation. So if there is a coronavirus, there are exceptions in the Patent Act by which there are provisions for compulsory licensing. So you will be able to obtain a compulsory license, and governments can also override the Patents Act. So yes, patent will be granted, but then the company may not be able to enforce that patent owing to grant of compulsory licenses by the government, or overriding the Patents Act to say that you cannot enforce this patent in view of the pandemic situation, and therefore public health is of greater importance than patent law protection. So those exceptions are provided under patent law in case of public health emergencies to override the Patent Act and allow usage of that without. So you understand, patent is a grant given by the government for you to stop other people. That right will be taken away by the government in the case of public health issues. So pharmaceuticals which are required for public health, then public health will override the patent statute and will be able to give compulsory license. Of course, in these cases, the patent owner would also be, I think, responsible enough to understand that he should not be enforcing his patent rights for a period or within a certain price, or have it available for people who can afford it at a certain price, but make it available to the poor at a cheaper price. So there can be all kinds of permutations and combinations, but the government and the grantor of patents right would work with the patentee to open up the patent sufficiently to control the pandemic, which would be the first aspect, and then monetary gains for the patentee has to be looked at secondary. So it can be sort of monitored to that effect. But patent rights, to answer your question, yes, will be given. The government cannot say if it's a new and novel, new new pharmaceutical or vaccine, that I will not grant patent rights. I will grant patent rights, but then take them away or suspend them for a while till the pandemic is on, and not allow you to make so much money, or allow you to make less money or no money at all.
Okay, sir. Thank you so much, sir.
That's a good question and very
Is there
relevant
any more
for today's day and age.
Yes, sir. Thank you.
Yeah.
Is there any more question? So now I would like to invite Principal Ma'am, Dr. Subhda Gopal Ma'am, to present vote of thanks.
Thank you, sir. Good afternoon to all. Today, Mr. Chander
Vote of thanks.
Hello. Hello, I am here to give vote of thanks. Today, Mr. Chanderlal covered all the 4 aspects of IPR, namely trademark, design, copyright, and patents with practical examples. It was a wonderful experience to listen to him. So on behalf of Yashwantrao Chauhan Law College, I am thankful to Honorable Mr. Chanderlal, Senior Advocate, Supreme Court of India, and founder partner Lall and Sethi for delivering enlightening deliberation on intellectual property rights. I am also thankful to Burnish Law School for their collaboration with us for organization of this seminar. I also express my thanks to join this workshop and giving a good response to make it successful. Thank you.
Thank you very much.
Thank you so much, ma'am, your words, and thank you so much, sir, for joining us, giving your
Thank you.
time for joining us successful this event. Thanks everybody. Thanks, BA sir. Thanks, Principal ma'am. Special thanks to you, sir.
Thank you.
And those who are interested in paper publication, please visit our website, burnislawjournal.in, and publish your paper in our journal. Thank you. Thanks, everyone.